I welcome this legislation on insolvency and bankruptcy, which has been a long overdue. After we opened up our economy and started soliciting investments from abroad, such investors have been making their investments basing on not only the returns on investments but also the statutory and legal framework for the protection and safety of their investments. The foreign investors basically looked at the ease of doing business with us. Since I have commenced my role as a parliamentarian about 2 years back, I have seen the sincerity and commitment with which the Honorable Prime Minister and Honorable Finance Minister have initiated measures in doing away with number of redundant laws and in bringing in fresh legislations in the required areas which will remove the irritant and promote investments both from abroad and within the country. This proactiveness of the part of the government is commendable, and we look forward to more such initiatives to ensure efficiency in managing our economy. Insolvency and bankruptcy laws of our country have been the major bone of contention for many investors, mainly because of the multiple number of laws and the time taken for the resolution of the dispute. This makes recovery of debt a cumbersome process. The multiplicity and the redundancy of these laws are making mockery of our financial system. India is a capital-starved country, and therefore it is essential that capital is not frittered away on weak and unviable businesses. Quick resolution of bankruptcy can ensure this. The passage of this bill will enable quick and prompt action to be taken in the early stages of debt default by a firm, maximizing the recovery amount. The creditors will not become victims of red tape, and promoters will directly become accountable for any financial lapse. Bankruptcy laws accept that business ventures can fail and allow entrepreneurs to get a fresh start. Currently, it takes on an average more than 4 years to resolve insolvency in India. According to the World Bank's Ease of Doing Business report, the new code seeks to cut down the time to less than a year. India is ranked 136 among 189 countries in the World Bank's Ease of Doing Business Index in the category of resolving insolvency. India's overall ranking is 130. This act and similar other acts in the pipeline will push not only the rank up but also the image of our country. Sir, we all know that our banks are saddled with huge amount of NPAs, thereby choking the financial system. Time has come to overhaul the laws prevalent in our country, especially the laws concerning the financial sector. This legislation is meant to connect the various laws and consolidation India's insolvency and bankruptcy laws, which governs bankruptcy and solvency for all debtors, including companies, unlimited liability partnerships, limited liability partnerships, individuals, and other entities. The code is aligned with the government's initiative to make doing business in India easier, and even creditors residing outside India are, including the definition of creditor. Sir, the Insolvency and Bankruptcy Code 2015 is a welcoming initiative for creditors, investors, and debtors alike. The streamlining of procedures, simplification of the insolvency process, and fast-tracking of recovery are hallmark of the code, which will have a positive effect on India's leading climate. The code allows investors to exit from failing projects. The failure of businesses impacts employees, shareholders, lenders, and broader economy. In a country like India, particularly because of tactics employed by company promoters to deal reorganizations or attempts to sell off assets, change of management, or Litigation that goes on and on has significant bearing on jobs, income generating and economic growth. The major initiative for the lenders, sir, 1 minute, sir. The major initiative for the lenders and investors is the change in the order of priority of charges. Government taxes have been relegated to the position below the creditors and employees, thus giving confidence to the lenders and investors. The government shall put in mechanism to collect taxes as and when due, instead of allowing them to be accumulated to a level for recovery through liquidation. Another significant feature is inclusion of penal provisions in the bill, which provides for monetary penalty and jail term of up to 5 years for concealment of property, defrauding creditors and furnishing false information. This, I hope, will act as a deterrent for the potential wrongdoers. Sir, even while supporting this bill wholeheartedly, I would like to express my concern and reservation on one aspect, that is, appeal process provided in the bill subject to correction, if any. I hope the Honorable Finance Minister will give a serious thought to this aspect, especially in view of length and breadth of the country. As per the provisions of the bill, National Company Law Tribunal and Debt Recovery Tribunal are the adjudicating authorities. Their decisions, sir, half a minute, sir. Their decisions could be challenged in appellate tribunals. These appellate tribunals are located in the national capital or at the most in metropolitan cities, and the further appeal is only to Supreme Court of India. This will increase the cost of appeal process and will be burdensome on the people. The high courts which are there in every state capital have been totally left out in the scheme of arrangement. If the appeal process could be restructured to allow the appeal from National Company Law Tribunal and Debt Recovery Tribunal, or even from the appellate tribunals to the high courts and finally to the Supreme Court, it will be a great convenience and financial relief to the parties involved. With these observations, I strongly recommend this bill passing and looking forward to similar enactments which will strengthen our economy. Thank you, sir.
लॉ एंड ऑर्डर स्टेट का विषय है और इस फर्जीवाड़े के लिए जब कानूनी कार्रवाई करनी होगी तो वो स्टेट सरकार के अंतर्गत ही इस वक्त संवैधानिक ढांचे और प्रक्रिया के आधार पर संभव है।